Hello and welcome to this UK Employment Law Essentials webinar. My name is Ian Machray and I am a partner in the employment team here at Field Seymour Parks. So this is designed to be a practical guide for global HR and legal teams on obviously UK employment law, but also may well be helpful for anyone who is new to the area regardless of where you're based. So before I get started, just a few housekeeping things. You will have noticed that you're all on mute. It's just because of the numbers that we had registered for this event. It was difficult to have you all throwing questions at me verbally. But what you will find, hopefully, on your control panel on the session, there is a little box with a question mark in it. If you click on that, you can type in any questions that you have throughout the session. And what I'm going to do is leave some time at the end to try and pick up any questions that people have. So please do use that question box function. There's also another little icon that has a sort of like a document with a paper clip on it. If you click into there, then hopefully you should be able to download the slides from today as well. The other thing I would mention, obviously, is a live webinar. Hopefully we won't have any technical issues, but if so, bear with me and we'll try and sort them out as quickly as we can. And during the course of the presentation, we've got a few sort of polls set up where you'll be able to sort of vote and interact, and it'd be great if you can engage in those because it will save me just talking to myself and make sure I know that somebody's out there and listening. But thanks for attending today. Before we get into the bulk of what we're going to talk about, I thought I would briefly introduce Field Seymour Parks and also our international network, Global Advocaten. So Field Seymour Parks, we are based in Reading in England, which is just outside London. We're a single site firm. We've got about 140 people here in our offices, and we carry out all manner of commercial and corporate work, obviously including employment and immigration services. But we also have a private client wing as well that deals with work for individuals. We pride ourselves on giving sort of practical, pragmatic advice, which I will try and live up to in this session today. So obviously we are based in England. We only advise on the laws of England and Wales, but we are fortunate to be part of a global international network called Global Advocaten, which some of you may be aware of, and indeed some of the people attending will be members of it as well. But essentially what we find is that allows us to offer our clients sort of cross-border support, introducing them and working with like-minded law firms in other jurisdictions, so we can essentially offer a one-stop shop regardless of the legal jurisdiction that applies. Right. Moving on then. So what are we going to cover in this session? Well, it's essentially going to be a high-level summary of UK employment law. I'm not going to be able to get into all the details of everything, as you might expect in an hour. But what I'm going to do is to identify areas of risk or things that you need to be aware of, so that hopefully you can identify them and obviously take further advice or look into an area in more detail as and when required. So I'll start with introducing English employment law. I'm then going to talk about Brexit briefly, which is always a highly charged topic in the UK, but we do need to talk about it at least a little bit today. We'll then talk about, if you are new to setting up a business in the UK, a few things to think about there. Employment status, which is basically getting the status of the people working for you correct. And then essentially we're going to sort of run through the employment relationship. So I'm going to tell you about things you need to be aware of at the start, things you need to be aware of during employment, and then if you are terminating employment at the end, risk and compliance issues to be aware of then. I will then talk a little bit about what happens or what might happen if you get it wrong, so enforcement and risk issues, and then I will touch upon there's a huge number of changes coming to English employment law over the course of this year and next, and I'll highlight some of the key ones for you to be aware of. And as I say, at the end, I am planning to leave time for questions and answers. So if anyone missed me saying it at the start, there is a little question box on your screen, hopefully, which you can click into and then type your questions in there, and I will pick them up at the end. So to start us off, I thought I would ask a question and a poll, which my colleague will get up. And essentially the question, just to get us started, is how confident do you feel currently on navigating UK employment law? So only giving you 4 options, but please do vote as and when you can. So your options are very confident, somewhat confident, not confident, or you're completely new to it. So you've got various different options you can choose. I thought I'd just ask. Obviously, the hope will be by the end of the session that you will feel more confident than you do currently. But it's, yeah, how confident you feel navigating it. So I think we've got the results up there. So 54% of you feeling somewhat confident. That's pretty good going. And then we've got 8% not confident and 38% completely new to it. Well, hopefully there will be something. You haven't got anyone who's very confident, which probably makes sense, or otherwise you wouldn't be attending the session. But hopefully all of you will have something that you can take away from the session today. Right, let's start talking about English employment law. So the first thing to flag is that we have slightly different jurisdictions and laws within the United Kingdom. So we have the laws of England and Wales, we have a legal system in Scotland, and we have a legal system in Northern Ireland. Now, there are many similarities between them, but there are some distinct differences as well. So a lot of what I say today will apply across all of those areas. But ultimately, if you have got an employee who is resident or working in, for example, Scotland or Northern Ireland, I would recommend that you'll need to take local legal advice there. Luckily, we have very good connections with our Scottish counterpart in Global Advocating called Inova Law, who can advise you on Scottish employment law issues. And we also have a number of strong connections with firms in Northern Ireland as well. So just something to be aware of. It is not all exactly the same. The other thing I was just going to highlight is, unfortunately, particularly if you're relatively new to the topic, UK employment law is found in multiple different places. So we sort of have Acts of Parliament, which is laws passed by our Parliament here. We have government regulations. We then have contract law, because that is the essence of employment contracts in the UK. We have a duty of care under tort law. We then have lots of different decided cases. And then we still have laws that have been assimilated, essentially laws that have been retained from when we were members of the EU. And then on top of all of that, we have various different sort of statutory codes of practice and guidance. So it's not always the easiest area to navigate because it is not consolidated in one place. Few key bodies to be aware of, because you may come across them if you're dealing with UK-based employees. ACAS is a guidance service for employees and employers, and it also runs a process called early conciliation, which essentially is a sort of a settlement process that employees have to go through before they can issue tribunal proceedings. The idea being is they try to help the employer and the employee resolve the issue before it actually ends up in the court or tribunal system. If that doesn't work, most cases are brought before the employment tribunal, which is basically a simplified court system, and there's an appeal process on that as well. I'll talk about that a little more at the end when we come on to enforcement. Equality and Human Rights Commissions, they've got various enforcement powers, principally concerning equality and diversity. And then His Majesty's Revenue and Customs, somewhat unsurprisingly, they are of particularly interested in anything that relates to money or tax. So that's the sort of building blocks of what we're going to talk about. Before we actually get into some of the different laws, a question we are often asked is, well, how does it differ since Brexit? So we left the European Union on the 31st of January 2020, and there was a transition period through until the end of that year, so through until the end of December 2020. What's changed since then? Well, not a huge amount. So we still have a lot of law in this country that originally derives from EU legislation, particularly in the employment sphere. So we have working time regulations that deal with holiday and rest breaks. We have 2P protections, which is about sale of a business, and protections for employees there, which I'll explain a bit more later. And then a lot of our discrimination protection is influenced or originates from the EU as well. So a lot is still the same. The two things that are where we've had differences are, one is where the UK government has started to play with some of those things. So we have a different approach to holiday pay calculations. We have a different approach to recording working hours now. And the other one is where the EU is moving forward with its own agenda. And I've put a few directives on the slide there that are have come into force or are coming into force in the EU, but that will not apply in the UK. There is a slight limit on how far apart we can sort of become. We do have the UK and EU trade and cooperation agreement, which is about our trading relationship. And that essentially says that neither party must not weaken labour protection as it was at the 31st of December 2020 in a way that's going to impact trade or investment. So there was a lot of speculation in the UK pre-Brexit that we were going to have this bonfire of regulations. That hasn't quite materialised because there is still some checks and limits on that if we still want to have the agreed trading relationship with the EU. Right, going to look at a few things in terms of this might be relevant if you are looking to set up in the UK or you're already here and looking to bring people in. I am moving slightly outside my area of expertise because I'm an employment lawyer, not an immigration lawyer, but we do have a team that deals with these issues, and I've put their details on the slide in case that's useful. But ultimately, there are various routes to bring your employees or workers into the UK. They're all subject to different conditions. I've put the main ones on the slide. There are also sector-specific accesses, like, for example, healthcare has some specific sort of routes into the UK, but I've put the main ones on. So they're somewhat self-explanatory, but skilled worker visa, essentially for skilled workers, somewhat surprisingly, they need to have a job offer. The employer needs to have a sponsor license in the UK. And there are sort of skill and salary thresholds that you have to overcome for that employee to come in on that basis. Global business mobility, that's really intra-company transfers. Again, you need to have a sponsor license in the UK entity, and there's certain salary thresholds on those as well. Global talent visas is where you have a leader in academia, research, arts, culture, technology. They can come in via that route. A high potential individual is essentially a graduate from a top university. Innovator founder is experienced entrepreneurs who've got a scale up business that they want to operate in the UK. And then you'll also find that some individuals will have routes to live and work in the UK because of their personal circumstances. So because of their spouse, because of their partner, or maybe because of their ancestry. If in any doubt, do get in touch. My colleagues will be delighted to help. One thing I would mention regardless is you do in the UK have a right and an obligation to check that your employees have a right to work in the UK. So before they start employment, you have to have established that they have the right to work here. And if not, there are fines and potentially criminal sanctions as well. Right, similar topic, but a question we often get asked is for businesses that are looking to set up in the UK. How can we do that? What's the best way to sort of engage with someone in the UK? And broadly speaking, there are 4 options. First one is you just establish a local entity. So maybe you set up a subsidiary in the UK. Obviously, it's a business that you will have full control over. So you've got flexibility. But equally, you will have to ensure full compliance with employment legislation and tax legislation. The other option is using an employer of record. So that is permitted in the UK. I know it's not in some jurisdictions, but that is, for those of you who aren't familiar with it, that's the idea of an organization that essentially employs the people you want to work for you. They sort out their tax and compliance, and then those individuals provide their services via that entity into your business. It reduces your obligations on compliance and tax. It does obviously come at a cost because they don't do it for free. And you also need to check your contractual relationship with the employer of record to see who actually bears the liability if it goes wrong. Third option is you can employ via an overseas company. That is also permitted. You will need to ensure local compliance with tax and employment laws. And there is a slight wrinkle that you need to be a little bit careful as to whether there's tax implications if the foreign company is deemed a permanent establishment. So it's something to watch, but it is possible. And then the fourth option that is often quite attractive is, instead of having sort of a full employee in the UK, you have someone under a sort of self-employed contractor basis. And that's often quite attractive because self-employed contractors in the UK, which I'll explain more about in a moment, they have quite limited legal protections. And also they are normally, not always, but normally responsible for their own tax. The tricky thing is ensuring that the person you are treating as sort of self-employed would actually be deemed self-employed under UK law. Which leads me nicely on to employment status. So one of the most important things when dealing with UK employment law is understanding the status of the people you've got providing services for you. And the reason it's important is obviously there are various different legal protections and they vary depending upon the status of the person who's working for you. Also, the tax that is payable varies depending upon that status as well. In simple terms, the key thing to understand here, as far as UK law is concerned, is that whether someone is, for example, employed or self-employed, what the courts and indeed the taxman are interested in is what is the reality of the relationship, what's actually happening in practice. You can have a contract with the individual, and it can say self-employed contractor. You can agree with them, you can both agree that they want to be self-employed. That won't be determinative. It's actually what is the essence of the relationship, not how you've chosen to label it. Now, for UK employment law purposes, there are, in simple terms, three different classifications of individuals providing services. So at one end of the scale, you have sort of a full employee. So what you'd normally expect to see there is what we would call mutuality of obligation. So you are obliged to give them work and they are obliged to do it. You have control over their working arrangements, hours, how they do things, where they do things. And normally an employee has very limited financial risk. They're not incurring costs and their salary is normally guaranteed. They get the full protection of the law. So everything I'm going to talk about today, the employees would get protection from it. So that's at one end of the scale. At the other end, you have sort of self-employed. So that is a business-to-business relationship. The individual should normally control how and when they undertake the services that have been instructed. They will normally take some financial risk as well. So there might be expenses they meet. They might have to, if they do a bad job, they might have to put it right at their own costs rather than an employee who just would get paid for maybe the additional time. And they have very limited rights, very limited, some health and safety, some discrimination protection, but that's about it. And then in the middle, you have the one that catches a lot of people out, which is the idea of a worker. So someone is a worker is someone who is providing services personally. So it is just them that is doing it normally. And they are not in business on their own account. So they're not running a business. And if they fall into that category, then they get some rights like holiday, national minimum wage, protection from discrimination, but not all of them. And that's the area where we've seen a lot of case law and litigation, where most commonly people who have been treated as self-employed, actually, as far as the law is concerned, are workers. So I've told you what it is for employment law purposes, and just to confuse you, The test for tax purposes is slightly different. So for tax purposes, UK law only recognises two statuses, not three. It is either employment or self-employment. So if you have a worker, they will be somewhere in between, and you've got to work out which side of the divide they sit. And the tax consequences are different depending on which way it goes. There is an online tool which you can find quite easily by searching. It's called the CESS tool. It's a check employment status for tax, and you fill in questions online. It's a government tool, and it will give you an indication of whether they are employed or self-employed for tax purposes. So it's a bit simplistic, but it's a useful tool. Right, well, let's assume you are taking on an employee. What do you need to be thinking about? Well, the first thing is UK employment law is based around contract law. So every employee has to have a contract. That can be a verbal contract, but there are certain minimum terms that need to be set out in writing. So I've put them on the slide there, or a summary of them on the slide there. They need to be provided before the employee starts work. Most commonly, they will be built into an employment contract where you will cover these things and you will cover other stuff that you want to make sure is dealt with as well. So you have to get that sort of employment contract out before they start work. What other things do you need to be thinking about when you're taking somebody on? Well, we do have minimum wage in the UK, or living wage is what the top rate is called. That varies depending upon the age of the employee. The top rate at the moment is £12.21 an hour. It's due to increase in April, and it increases every year. What else in the contract? Well, you will probably want some confidentiality clauses. Post-termination restrictions is an area for focus as well. So if you want to restrict the employee after the end of their employment, you'll need to include clauses in their employment contract. So that most typically would be something like, you shall not work for a competitor for a period of time, you shall not pinch our clients, etc. Now, the way UK employment law works on those is that those clauses are void and unenforceable unless you can establish you've got a legitimate business interest. So it could be confidential information they've has access to, or business connections, but that's your first stage. And then you have to establish the clause only goes as far as is necessary to protect that interest. What that means in practice is that if you do want to restrict an employee after their employment comes to an end, those clauses need to be really tightly drafted. They'll need to be time limited, and they'll need to narrow down on what is the interest you're looking to protect. What we often find is clauses that are drafted for other jurisdictions don't work in the UK, and I suspect the same would be vice versa as well. There is no requirement on this post-termination restrictions for there to be any additional payment for them, which I know is the case in some other jurisdictions. You've then got some minimum notice periods. So if you want to dismiss the employee, there are some minimum notice periods that will apply. You can agree longer notice periods, and indeed that's quite common, particularly for more senior employees. And any employee will have an entitlement to be enrolled into a pension scheme. That has to give them at least an 8% benefit, 3% of which has to come from the employer. Final thing I'll say on contracts, what we do offer is a free review of template contracts for our clients and contacts. So if you have got a foreign contract or you've got a UK contract and you're not sure it's compliant, we would be very happy to have a quick look at it for you and let you know if there's any issues. Right, to check I haven't sent you all completely to sleep with that start, we've got another poll up, which we'll get up now. Excuse me. Which relates to UK specific employment policies. So do you currently have UK specific employment policies? You've got 4 options again. Yes, bespoke to the UK. Yes, adapted from global policies. No, or not yet required, because maybe you haven't got any UK employees yet. But please vote when you're ready. And then what I'm going to do is I'm going to take you through some of the policies you would need to think about, or that are recommended if you're going to have a UK-based workforce. And there are different ways you can essentially go about it. So there's the poll. So you've got 31% bespoke to the UK. Well, that's very good and nice and easy to be compliant. You can also adapt them from global policies. So I think 8% of you have gone from that. And then we've got 62% in total who don't have those currently. Well, let me take you through what are the types of policies that you need to be thinking about. So there are certain policies that are essentially mandatory. So you need these. First one is, or first two, I guess, really, is disciplinary and grievance procedures. Yeah, those are required to have those by law in writing. You also have to give certain pension information in writing. And if you've got 5+ employees, you have to give a health and safety statement. So it's quite a short list that are mandatory required. There are then another relatively short list of ones that we would recommend or are recommended for legal reasons. So an equal opportunities policy, because it's an important part of defending certain discrimination claims. A sexual harassment policy, because all employers in the UK have a duty to try and prevent sexual harassment of their employees. A bribery or should really be anti-bribery policy, because you are expected to have adequate procedures to prevent bribery, and a policy will be an important part of that. Data protection laws, a bit outside the scope of what we're talking about today, but we have essentially very similar data protection laws to EU GDPR. That's where it originated from, and it hasn't changed much since. So you'll likely need a data protection policy and some privacy notices talking about how you use employee data. And then you are also expected to have reasonable procedures to prevent tax evasion as well. So a policy of some sort on that would also be strongly recommended. You can also obviously have 1,000,001 other policies as well, and whether that's dealing with the different employment protections that I'm going to talk about, or whether it's sort of family-friendly policies or codes of conduct, you can obviously do what you want, but I've focused here on the ones that have particular legal ramifications. As I say, you can have UK-specific policies. You can have global policies that are either adapted to the UK or have an annex or something on the back of them. We can do that. We've helped with that for many clients as well, because you want that consistency, but you also want to ensure you've got compliance in the UK. Right, this is a bit of a big topic really, but so we've got our employee, we've done our contracts, we've done our policies. What sort of things do we need to be aware of or concerned about during the course of employment? So first one is working time. So there is a maximum 48-hour working week in the UK. The difference from a number of other jurisdictions is employees can opt out of that working week. So if you've got a written opt-out subject to certain conditions, they can work more than 48 hours. Meant to have 11 hours of daily rest and 24 hours of weekly rest. Obviously, the rest periods can be longer than that. Those are the minimums. Similar thing, there is a paid holiday entitlement. It is 5.6 weeks, which for a full-time employee is 28 days. We have 8 public or bank holidays in England and Wales. So for a full-time employee, you could meet that obligation by offering 20 days of when they like, plus the 8 bank or public holidays. That would meet the requirement. Or alternatively, you could have them working on the public holidays as long as they get the 28 days at some point throughout the course of a year. Sick pay. So there is a statutory sick pay regime. Currently, it only kicks in for incapacity or illness on the 4th day. So the first 3 days are unpaid. It's also at a statutory rate, which is currently £118.75 a week. Which is not a huge amount if you're a well-paid employee. And as such, many employers will often offer some element of contractual sick pay, but that is your choice. You do not have to do so. One thing to be aware of from April, statutory sick pay will become payable on the first day of sort of incapacity or illness rather than the 4th. Various family-friendly rights, that's a webinar in itself, but maternity, paternity, adoption leave. We also have shared parental leave, which is, in simple terms, most commonly used when the mother shares their maternity leave with their partner. also have a right to request flexible working in the UK. So you could request, for example, part-time hours or working from home. You have a right to request that, and the employer has to consider it, but they don't have to agree to it. There's 8 grounds on which they can turn it down. But you have, if you get that request in, you do have to deal with it. As I've already mentioned, disciplinary and grievance procedures. Any misconduct issue, if you want to give a warning or even obviously leading up to dismissal, any sort of disciplinary sanction, you have to follow a formal process before you impose that. So you can't sort of give verbal warnings or anything like that unless you've followed a full process. I'll talk a little bit about what that looks like in due course. And you also have to follow a formal process if you get written employee complaints. So if you get a grievance in, a written complaint in, you will have to follow a formal process to deal with that. Other thing during employment, which is a bit wide-ranging, but an important one, is there is an implied term of trust and confidence in every contract. What that means in simple terms is, as an employer, you should not act in a manner that is calculated or likely to cause a breakdown in the relationship of trust and confidence. What does that mean in practice? Well, a lot of it is about acting reasonably towards your employees. If you fail to do so, you can be in breach of their employment contract, and they can also resign and claim the same rights as if you had dismissed them. Various rights to join trade unions and for collective bargaining in the UK. Union membership is very patchy depending upon what sector you're in. And then, as I mentioned earlier on, we have what's called the TUPE regulations, or that's their short form name. It's similar to the Acquired Rights Directive in the EU, but essentially it provides particular protection for employees where there is a sale of a business or sale of part of a business, or where there is outsourcing of services. In insourcing of services, you're bringing those services back in-house, or there is a change in the service provider of outsourced services. It's slightly broader than the EU regulations that gave birth to them, but that's something to be aware of if you have any of those situations. The other thing to mention that stems throughout the employment contract, so before, during, and after, is there's protection from discrimination. And it's discrimination on what we call protected characteristics. I've listed the ones on the slide that apply in the UK. And the thing I should add here is, you might guess on the basis that it applies before, during, and after employment, there is no service requirement for a discrimination claim. You could bring a discrimination claim before you are even employed, or you could bring one on day one of employment. The types of discrimination that are prohibited or protected: direct discrimination, which is less favorable treatment because of a protected characteristic. So that might be turning someone down for a job because of their sexual orientation. Indirect discrimination, which is where you essentially have a policy that treats everyone the same, but that policy has a particular adverse effect on a group of people who share a protected characteristic. So if you had a dress code that banned headscarves, that would obviously have a particular impact on people of a certain religion, because it will impact on religious attire. You would need to be able to justify that requirement. Harassment, that's unwanted behavior linked to a protected characteristic. So it could be teasing someone about their age. Victimization is sort of second stage discrimination. So that is where someone has made a complaint of discrimination, or maybe supported somebody else with their complaint, and then you have treated them less favorably because they've done so. Disability: if someone qualifies as disabled under the Equality Act in the UK, you have a positive obligation to consider reasonable adjustments to ensure they're not disadvantaged as a result. So a couple of things to be aware of: that can be physical disabilities. It can also be mental health issues. If someone's disabled, you've got that positive obligation. What is reasonable will depend upon all the circumstances. It won't cover necessarily everything that's on the employee's wish list, and it has to take into account their role. And then you have equal pay claims, which is essentially trying to ensure that men and women get paid the same for equal work. And there are similar but not identical protections for part-time and fixed-term workers. Right, coming towards the end of employment now. The big risk, or the big thing to think about when terminating someone's employment in the UK is unfair dismissal rights. Now, currently, there is a service requirement on an employee to bring an unfair dismissal claim of 2 years. So if you don't have 2 years service, you can't bring an unfair dismissal claim unless you can establish it is automatically unfair. Automatically unfair are things of such like they've raised a health and safety concern and you've dismissed them as a result. They are pregnant and you've dismissed them as a result. They have made a whistleblowing disclosure revealing something in the public interest, and then you've dismissed them as a result. It's particular grounds. But assuming they can't establish that, as I say, they need 2 years service. And what that means as things currently stand is, leaving aside discrimination, these automatically unfair claims, if you have less than 2 years service in the UK, you have quite limited protections from dismissal. You have entitlement to notice and minimum notice periods, but possibly not that much else. Now, this is changing for the 1st of January 2027, where that qualifying period is going to be reduced down quite considerably to only 6 months. So if you've got an employee who's meeting that service requirement, what are the things you need to do to give effect to a fair dismissal and avoid a claim? Well, the 2 stages basically. One is you need a fair reason for the dismissal, and there are 5 in the UK. So it's conduct, capability, which would cover performance as well as sort of ill health or incapacity, redundancy, some sort of statutory restriction, which might be they no longer have the right to work in the UK. You might have to terminate them because of that. And then some other substantial reason, which can cover a whole host of things, but most commonly it is business reorganizations or trying to make some change to an employee's contract of employment, which they refuse to accept. So you need your fair reason. It's got to be one of the 5. And then you have to show that you have acted reasonably in treating that reason as a cause for termination. So got your reason, and then you have a reasonableness test underneath. Now, what does that mean in practice? It depends upon what your reason for termination is. But before I get into that, so I will get into a little bit more detail on the different types of termination and how you might handle them. I'm going to ask you another question, just to see, and this doesn't have to be of UK employees, it can be other employees, but which of the following type of dismissal do you find the most challenging? So conduct dismissal, so dismissing someone for misconduct, dismissing someone on performance, dealing with sickness is the 3rd option, redundancy is the 4th, and then I've put other for your 5th option. So this can be what you found most challenging in the UK, what you found most challenging in a different jurisdiction, or indeed what you just think might be the most challenging generally. And then I will dig into some of these different areas in a little bit more detail in terms of how things work in the UK. Right, so we've closed that off there. So most of you say sickness. Yeah, so 46% say sickness. I think that is a good comment. I would probably agree with that. The next highest is performance, and then conduct sort of is the other one. Redundancy and other you haven't picked. I think that is probably right. I would certainly say sickness when you've got a disability in the UK can be tricky, and obviously sometimes these are linked. And performance is the other tricky one, just because of the amount of time that can take. Before I get into more detail, let's get my next slide up and I'll talk about some of these areas. So we're short on time, and I want to leave time for questions as well at the end. But what I've tried to do is give you a little bit of guidance on some of these different terminations. So dealing with misconduct to begin with, as I hinted at early on, any disciplinary sanction requires a formal process. And in essence, what that formal process is you need a formal investigation, you then need a formal hearing, and then the employee has a right of appeal. You'll normally have different people dealing with each stage as well. the normal expectation is you won't dismiss someone for the first incident of discrimination. Misconduct. The normal expectation is that you would first give them a written warning. The next incident, you'd give them a final written warning, and finally, only then would you move to dismissal. The only exception to that is where you've got gross misconduct, which is conduct that is so serious that allows you to terminate without warning. So that could be things like dishonesty, theft, harassment, discrimination, something that basically means the employment relationship is no longer tenable going forward. There's an ACAS code of practice that can guide you on what that process looks like. It's available online, which is helpful. The thing that's not helpful, if you don't comply with it, the value of any claim could be uplifted by 25%. So capability, I've split it into two types. So performance first, it's very similar to a misconduct process in that the expectation is you will go through a warning pattern before you eventually dismiss. The way it differs is a misconduct process normally looks backwards and is essentially punishing the employee for something they've done wrong. A performance process is meant to be forward focused. So you should be setting objectives, clear objectives. You should be thinking about ways you could help the employee hit those objectives, and then you're giving them the opportunity to improve. And if they don't improve, warning, still not improving, final written warning, eventually through to dismissal. That can take multiple months, minimum of 3, could be 6, could be beyond that, depending upon the circumstances. The other side of capability is sort of incapacity. As I talked about before with sort of sickness, you will almost certainly need medical evidence as part of establishing a fair dismissal, and particularly if there's a disability, and you'll need to show that you've considered those reasonable adjustments to see if you can help the employee return to work or do their job to the standard required. Redundancy, none of you felt you had any issues with this, or you didn't think it was the most difficult anyway. The key things with that in the UK is you need to give early warning to the employees. You then need to consult with them about it, and you need to consider any alternatives to redundancy before you confirm them. So you'll have a process where people are sort of at risk, and you will only confirm the redundancies once you've gone through that process. If you are proposing 20 or more redundancies at a single establishment, like at a single site, normally that means, in a 90-day period, there are further formal consultation obligations you have to follow, either with a trade union or employee representatives. And anyone who's made redundant, in addition to notice, gets a statutory redundancy payment. There are calculators online, but it's based on age, length of service, and salary. Right. So obviously the idea of this session is you don't get anything wrong, or at least you have enough knowledge to know when to get advice and check things out. But what happens if it does go wrong? Well, most of the claims I've talked about today, if an employee wants to complain about them, they get brought before an employment tribunal. Before an employee is entitled to do so, they have to go through the ACAS early conciliation process, which, as I mentioned earlier, is designed to see if the matter can be settled before it goes before it basically bothers the court or tribunal system. That can last 12 weeks. If that isn't successful, then the employee can then bring their employment tribunal claim against you. The tribunal process is meant to be quite informal, and it's meant to be fast. There are no wigs. I think everyone thinks all lawyers in England wear wigs. Well, they certainly don't in the employment tribunal. To be honest, it's not operating particularly well at the moment. It is underfunded. So what was previously meant to be something that would be resolved in a matter of months, even the most simple cases are taking a year, and anything more complex could be well in advance of that. So probably not operating quite as it's meant to. But in the tribunal process, you don't have to have a legal representative if you don't want one, and that applies to the employee as well. And if you do have a legal representative, each party generally pays their own costs. So the loser doesn't generally pay the winner's costs. Each party bears their own, unless there's some sort of unreasonable conduct. And these claims, tribunal claims, normally need to be started, or the ACAS process needs to be started within 3 months of the incident or 3 months of the dismissal. that is increasing from October this year to 6 months. What's this all worth? What's the damages when it goes wrong? Well, somewhat unsurprisingly, it depends upon the claim that the employee has brought against you. But if we look at unfair dismissal as one of the most common ones to begin with, there are essentially two heads of loss there. One is what's called the basic award. That is essentially the same as a statutory redundancy payment. So you can do the calculation online, but it's age, length of service, and wage. Normally, the more valuable part of that claim is what's called the compensatory award, and that is designed to compensate the employee for the losses they suffer as a result of losing their job. So loss of salary, loss of benefits, loss of pension. The employee has an obligation to mitigate their loss. So for most employees, that is get out and find another job. And if they fail to do so, the value of their claim can be reduced down. Unfair dismissal compensatory award is currently subject to a cap. So it is a maximum of 52 weeks pay or around £118,000, whichever is the less. That cap is to be removed on the 1st of January 2027. So from that point forward, you'll only need 6 months for an unfair dismissal claim, and there will be no cap on the value of that claim at all, which I understand is quite unusual in comparison to even countries that are considered to have sort of more stringent employment protections. Other type of claim to touch upon, possibility of a discrimination claim. They already have an uncapped value, so you can recover financial compensation for those, but you can also recover injury to feelings award for a discrimination claim. You can't get that for unfair dismissal. Unfair dismissal is focused on financial matters only, but you can with a discrimination claim, and you can also get sort of aggravated or exemplary damages if you have done something really wrong. As I mentioned before, there are various different sort of ACAS codes of practice out there. If you don't comply with them, you could end up finding your award against you being increased by 25%. Quick word on settlement. So if you have got a dispute and you want to try and get rid of it before it goes to a tribunal, there are two ways you can do that. One is you can do it through ACAS, as I've talked about before their process. They can get a binding settlement. The other way is by entering into a formal settlement agreement with the employee, which is in a sense a contract that settles their claims. And you can include, confidentiality clauses and whatever else you like in there within reason. The tricky thing with those settlement agreements is the employee has to have independent legal advice before they sign it. If they don't have that advice, the agreement, the settlement part of the agreement is not binding on them. So they can take whatever settlement sum you've decided to pay them, put that in their pocket, and still bring a claim against you in any event. So that is one to certainly get right. Right, going to finish off with a final poll, and then I'm going to see if we can take some questions, see if anyone's got anything for me. So before we get on to that, I've talked a little bit about tribunals. I just wondered, having heard that, what do you find most concerning about UK tribunal risk? So the options you've got is damages, which might be more of a concern from the 1st of January 2027 when they're uncapped, legal costs, time and resources, reputational impact, or uncertain outcome and timings. I'm afraid you can only pick one. I suspect you might want to say all of them, but just tell me the one you think is most concerning. I'll then tell you what I think. What I think is the main risk for employers on this stuff. Right. Oh, we've got a bit of a mix, but a clear sort of high one, which is time and resource. And that's what I would say. That is your biggest risk in that, yes, you can incur legal costs in defending claims. Obviously, our costs are incredibly reasonable. But that is a problem, and you can face damages. But what you can sometimes find is you've got a low value claim from an employee, but it is going to suck up a load of time internally, management time, producing documents, preparing witness statements, attending hearings. That is a real risk. Reputational impact, just comment on that briefly. That can be a problem. Judgments are published in the UK, so future employees can search if they want on whether their potential new employer has got judgments against them. And the uncertain outcomes and timing, I would agree with that as well. Even when we have a very strong defense on a claim, it's very difficult for us to offer absolute certainty that you're going to successfully defend it, because whilst the tribunal process is rather slow at the minute, it is still quite rough justice. It's designed to be quite an informal process. It's not like the sort of Rolls-Royce court system of the High Court we have in the UK. Right, let's move on. I've got one final thing to talk about, and then we'll see if there's some questions to pick up. So, yeah, it's just looking ahead. So, as some of you may have been aware, the Labour government has introduced a new bill, the Employment Rights Act, which was passed in December of last year, so 2025. It is introducing a whole raft of new employment protections or enhanced employment protections, and they're coming in sort of drip by drip throughout 2026 and then again in 2027. It has been a bit controversial, certainly some of the changes. So the key ones, there's too much to go through in a few moments, but we've got some changes to leave rights, which will become day one rights in April. Previously, they had qualifying service. From October of this year, there's enhanced protection against harassment, including harassment by third parties. We've got changes to what we commonly call fire and rehire, but that's making it more difficult to change employees' terms and conditions of employment mid-employment. Trade unions are going to have enhanced rights to contact and have access to premises to recruit employees to join their union. I've talked about the tribunal time limit being extended. The unfair dismissal qualifying period is going to have a big impact. That changes to 6 months on the 1st of January 2027. And then we have changes to 0 hours contracts, which we still have in the UK, and they are permitted. So contracts where there's no work guaranteed. But excuse me, that's going to become more difficult. That's going to become more difficult from 2027. Right. So it's only a summary. Please do take legal advice on your own circumstances. There's a feedback form at the end. If you can fill that in, that would be great. And there's also an option in there to subscribe to our various different updates. All right, the voice is coming back. It's okay. There's an option there to subscribe to our various different updates. We do a lot of free content throughout the year. So if you are interested in keeping up to date on employment law or indeed anything else, then you can subscribe on the feedback form. Right, let's see if we've got any questions, and then we'll sort of a couple of minutes on those, and then I will let you all get back to your day jobs. Let's have a look what we've got here. Can I elaborate on the distinction between workers and employees in Belgium, only distinguishing between an employee and a self-employed person? I can do my best. It's a bit of a blurred line. So the key thing often between an employee and a worker is an employee will have guaranteed hours and will obviously be expected to do those hours. So, whether it's 9 to 5, Monday to Friday, or a part-time role. A worker often won't have that same sort of what we would call mutuality of obligation. So it's commonly comes up when there's a 0 hours contract, which we have in the UK, where someone isn't guaranteed any work. And indeed, they may not even have to do it when it's offered. But when it is offered, they are doing it personally. So that it's not, them, or they can't get a substitute to come and do it. and they're not running a business either. So if you've ever got anyone who's self-employed, but they are the only person doing the work, and it doesn't really look like they're running a business, then you've got a potential risk. Question here on remote work. Is there any geographical restriction in terms of locations? No, I think the thing the issue we always have with remote working here, in that you could have a UK-based employee who works, anywhere in the world, or you could have an employee who's working in the UK from another jurisdiction. It's just whether or not you're triggering different employment protections or different tax implications by where they're based. If you've got remote workers, you are expected to, ensure they've got a safe working environment and comply with all the other requirements that you would have as if they are in an office. Let's have a look. What else have we got here? Is it common for UK employers to do background checks of prospective employees before hiring? And are there clear rules how they can do it? It's relatively common. So taking up references from past employers is certainly very common. The problem is in the UK, because everyone is risk adverse, all you will generally get is they worked for us from date to date and this was their role. And then a nice big disclaimer that's bigger than the information that's provided. So that's common. Sometimes criminal record checks are undertaken, but obviously with data protection issues, you have to be clear that you can justify that, and also how you use that data. And we have a principle here of sort of spent criminal convictions, which means that after a certain period of time, you're not permitted to take them into account. And then some employers will do wider checks on top of that as well, but that is increasingly less common. The references and the criminal record checks are the most common. Sometimes there's medicals and things like that, but it doesn't happen as often. I've got a few here. Which one? Works councils. Do we have works councils in England? Well, not really, no, not in the same way as you do elsewhere. So we don't have a mandatory work council regime. There are certain rights whereby employees can request under what we call the ICE regulation, ICE, where they can sort of request a body, but it's really rare that they do. So it is more common that there is consultation undertaken on a sort of a when needed basis, rather than sort of a standing body of representatives. Trade unions also have certain rights for negotiation, but as I say, they are very common in some of the traditional industries. You really do not see them in, for example, the tech sector at all. Can you have global employment policies that apply in the UK? Yes, I touched upon this earlier. So you can have global policies. All you will need to do is make sure that they're not cutting across and they are compliant with UK legislation. So as I say, you can have specific policies to cover the UK. If you don't want to do that, it's checking your global policies do what they need to do. And then if they don't, it's whether you can adapt them, or maybe you just have a UK specific addendum, which is a process we've done for clients in the past. Last one then, because we're running out of time, and I'll let you all go. I've got a couple here. Oh, that's probably a sensible one. Where do employers most often go wrong? So I guess this is really a question of where do people most commonly fall up. I do think the employment status one is tricky. We've had a lot of cases on that around, particularly sort of in the gig economy, so sort of food delivery and things of that nature, where people have been treated as self-employed and actually they've got much more enhanced protections than that. The other one I think that is tricky is performance processes. I think people often think they're going to be a lot quicker than they are, but under UK legislation, they are one of the more tricky dismissals and can potentially take multiple months. Right, well, I best leave it there so I stick to time, but thank you all very much. If there are any questions I haven't got to, I will try and come back to you separately. There's a feedback clause now that should pop up any moment, but thank you all very much for attending today, and my voice just about lasted till the end.